Welcome everyone. So you should all be here today for the HR exchange on investigations. So my name is Lindsay Gamester. I'm an employment solicitor. I'm also director and head of our employment team here. Today joining me is Phoebe, one of our senior HR advisors, and we've also got Nikita and Hannah, who are part of the legal team. They'll be on hand on the chat box, so please feel free to ask questions using the chat function. They'll answer as many as they can, and there's also going to be opportunities at the end for people to ask questions as well, so we will stick around. So let's get started. So a little bit about us. So hopefully a lot of you will be aware about who we are, what we do, but for those that are new to the HR exchange, welcome. So we are a independent law firm, but we just specialise in employment law, HR, and a little bit of commercial as well, just to make sure we can round off all your needs. We also do health and safety, we do a bit of recruitment. And essentially we're your one-stop shop for your, as I said, all your people management, employment needs. There you can just see a list of just some of the things that we do. That's quite a limited list. We offer so much more than that, but just in a nutshell, anything to do with performance, contracts, grievances, redundancies, discrimination, tribunal claims, training, that is us. We've won quite a few awards. We're very proud of firstly the level of service we give. Yeah, we pride ourselves in being different in terms of we always ask you, what do you want to achieve? What do you want? And our advice isn't legalistic. We want to make sure that you fully understand what we're saying. No one goes away feeling stupid or daft. And I think all our awards kind of show that we're achieving our goals in respect of that. So how can we help you? So we support your customer journey in lots of different ways, or your employee journey, should I say. So as you can see there, we've created our wheel. And as I said, this forms our basis for the majority of relationships with our clients. Right at the top, we can help you with your recruitment needs. So we know recruitment's a really difficult time at the moment. It's a difficult area. And then once you get someone in place, you've got to try and retain them. So that is how we have developed our program. So we look at your compliance, your culture, your values. How are you engaging with staff? What's your brand visibility like? Is there anything we can help in that respect? Then your live issues. So disciplinary, grievances, tribunal claims, those calls from Acas. Yeah, we can help with all those aspects. Workforce planning. So some companies are growing, which is great. We want to help with your succession planning. We want to help structure your teams, make sure that everyone's trained up and ready for for that imminent growth that you've got planned. Unfortunately, some companies are struggling, and we're looking at scaling back. We're looking at restructuring, but more in a sense of maybe combining job roles or making redundancies. We help with all that, and I'd like to say as well that the earlier we are involved, the more value we can add. We might be able to save those redundancies. We might be able to streamline your processes, make it less stressful for you and your staff. So get us involved early, and we might be able to offer you some more options than what you think are currently available. Training is a big key one. So your staff cannot do their job properly if they don't know what they're doing. And we see lots of examples, particularly of managers who are promoted because they're brilliant at what they do, but they're not necessarily leaders and managers. They need that extra support. They need a bit more training. So that's where we come in, and we have a variety of courses that we can offer. Particularly, I'll talk about it more at the end, but HR Essentials is really popular at the moment. So getting not only your HR teams up to date, but also your senior management teams, any leaders you think might benefit from having that understanding of HR. So it allows them to better manage the staff. Also, equality and diversity, again, is a key area. And we offer a variety of different courses for equality and diversity. It might save you from a tribunal claim, so please do look into that one. We also do HR software, health and safety assessment, and other services we offer is we've got our watertight, first of all, our watertight package, so we become your external HR support, but also we can parachute into your business and become your on-site HR if you need us for projects, or you need just extra support with a particular task that you're doing, such as say redundancies, or if you're doing some planning, we can come on board and help with that. Particularly, I enjoy getting involved in the board discussions around restructures, redundancies, because as I say, we can add so much value and provide different options for you that you might not realise are available. And also, as I said, we do company work as well. So shareholders, directors, any agreements, if you've got disputes around there, again, we can get involved and we can help. So that is about us. So let's move on to why we're here, which is how to conduct a workplace investigation. So the first question you might ask is, well, why is it so important? And I think the fact that you're here tells me why you know it's important. If you get it wrong, then we have distraction for your staff. Everyone loves a bit of gossip. It's like, oh, what's happened here? If you don't go about it in the right way, it can become just a wildfire for your staff to all get involved in, and then they're not doing the work properly. It's a drain on your management time and resources, so someone's got to deal with it. And if you're not dealing with it effectively, you're involving too many people, you're not involving enough people, it's going to get bigger. So we need to make sure that we're dealing with it properly right from the start to make sure it's an efficient process. It's costly in both time and money. So obviously, if you drag out an investigation, you might have someone suspended. That's going to cost the company money. You've got the time it takes for your staff to become involved. So that is not just the person investigating, it's those that are called to interview. As I said, anyone who is involved in this isn't doing their day-to-day job. It's going to affect productivity. Then a poorly managed investigation will damage staff morale and confidence in management and processes, which in turn will impact your staff retention. So if you aren't dealing with things properly, your employees will look at that and go, I don't have faith that they're going to be fair, or I don't believe that they treat everyone the same. And therefore, there's lots of companies now that are shouting out about their culture and how amazing they are. And we know from our own experience that it's not just about the money these days for employees, it's the whole package. If you're not being fair, if you're not being transparent, if your management aren't trained up, your HR aren't in the best place to support staff, then you probably are going to start losing staff. And then the ultimate thing that goes wrong if your investigation's done incorrectly is you'll get a claim. So that will be an employment tribunal claim. That's going to cost further management time, unrest amongst staff, reputational damage, and the cost. I can't tell you right now what that would cost you, because every claim is different, but I would say on average, defending a claim, you are talking between 10 and 15,000 easy. And that's before you get into your more complicated cases. That doesn't include the cost to your business. So this is why we need to be getting it right. Legal principle then. So what underpins a good investigation? So the first thing we've got to look at is unfair dismissal under the Employment Rights Act. And that breaks it down into two separate areas when it comes to investigations. We look at substantive fairness and procedural fairness. So in a nutshell, substantive fairness is the decision that is reached at the end, is it fair? Well, that decision can only be fair if the investigation was thorough and fair. So your investigation's wrong, you'll fail on substantive fairness, most likely, because your decision maker won't have all the facts available to them. And then we've got procedural fairness. So procedural fairness, again, is if the process is wrong, highly likely that the whole thing will be declared as an unfair dismissal. There's more to it than this, granted, but you can see how the investigation is your starting point for both of those legal tests. Then we move on to Acas. So you think, well, what have Acas got to do with it? Their guidance that they publish is non-statutory. it's actually not legally binding. However, the tribunal will look at this and they will say, have you followed the Acas guidelines? If you haven't, they can apply a 25% uplift on any award made. So that's going to cost your business even more money. So we do abide by the Acas guidelines to protect you, to protect your employees. Then we've got breach of contract. So we don't see it as often these days, and I cringe when that contract comes in that has embedded in it the disciplinary and grievance process as contractual rights. If you have received any of our contracts, you will know we do not embed them. We have to refer to disciplinary and grievance processes within our contracts of employment, but we specifically state the process is non-contractual, because if you have committed it to contract, you've got another claim on your hands if you don't follow your own rules. So please go and check your contracts. If it's in there, we might want to do some amendments and tweaks there, just because you're adding an extra layer of complexity to this that is just not needed. And then we've got discrimination. So a lot of people will know that unfair dismissal, you need 2 years service for to bring a claim. Discrimination, it's a day one right. In fact, it's not even a day one right. It's a right you accrue the moment you step into someone's door to interview, you send off an application form, you see an advert. That's the point in which discrimination is engaged for you as an employer. So when it comes to investigations, you've got to make sure you're treating everyone fairly. And the way you do that is make sure that, as I said, you're not singling anyone out. But also, if someone does have, say, for example, a disability, you're making reasonable adjustments to that process as well. So discrimination, again, can occur during the investigation process. It can make claims a lot more complicated and costly if they get to throw that in. Then we've got the key case that we always refer to when it comes to unfair dismissal, which is Birchall. And Birchall will look at, did the employer genuinely believe the employee to be guilty? Did the employer have reasonable grounds for believing that the employee was guilty? And then the third point, at the time it held that belief, had the employer carried out as much investigation as was reasonable? It's embedded, therefore, in all our case law that your investigation has got to be right. However, a key point there is as was reasonable. So what we're going to look at is to what extent do you need to investigate? You know, what is reasonable in the circumstances? And, you know, are we unturning every single stone here? Or will we be able to draw a line and say, well, I think we've done enough? So that's where we are on your legal side. So what happens then when we get to a point where we think, oh no, I think we might need an investigation? So we've got your initial considerations. What are the issues? Is this a disciplinary? Is this a grievance? So on both of those processes, an investigation will be needed. So has some misconduct come to your attention? Has someone raised a grievance? Both of those actions will trigger the need to investigate. So you need a full understanding at that point of, well, what is it that we're doing? Then you need to understand, well, who's involved? So if it was an incident, what employees, which employees is it involving? Who witnessed it? If it's a complaint or a grievance, who is it against? Again, who is involved, so that you can make sure then that your process tailors to that. And also you are not divulging information at an early stage that you shouldn't be. So I will explain that in more detail shortly, but to give you an example, if a grievance lands about, for example, a manager, it is not appropriate to send that grievance directly to that manager. So if you receive something in, something that you need to act on, it is your duty to think straight away, who needs to know about this now? How do I take this forward? Then we'll look at your policies. Policies are always important. It's the first thing a tribunal are going to ask is, have you got any written policies? If it's a disciplinary, you get out your disciplinary policy. If it's a grievance, you get out your policy. Those policies will guide you on timelines. They'll guide you on who should be doing what. For example, some grievance policies will say that a grievance will always need to be dealt with a manager one level higher or 2 level higher, or an appeal will need to be dealt with by this certain level. So we want to make sure that we are following your policy right from the start of this process. Then we need to start doing some planning. And to plan, we need to understand what is needed from each process. So your grievance, you will have someone that will investigate, and that will be the decision maker. And they are generally the same person. So that is different to disciplinary, where we will have an investigator. Then we will have a separate role as a disciplinary officer. Those two people shouldn't ideally be the same. We're going to look at, again, more detail as to what what that could mean if we get that part wrong. But the guidance that we get from Acas is that in an ideal world, your investigating officer should be separate from your disciplinary officer. Then for both of these processes, we need to think about who would conduct any appeal. And again, an appeal officer needs to be someone completely separate to your investigator, completely separate to your disciplinary officer. So it's good to have everyone, I suppose, in place at the beginning. And what I'm going to do later is, we're not going to do breakout rooms this time, just because I thought we're going to try something different. We're going to try an interactive quiz. Don't worry, there's no pressure. It's just going to take you through a scenario where we're going to look at the impacts of a grievance or a disciplinary on a small business, and how you'd go about allocating roles and what would be the best way to do that. So then you've got your people in place, but you've got to check then, are they trained? Do they know what they're doing? Have they done this before? What support are they going to need to be able to do this? And that leads us on to, have you got adequate HR support? And that is super important, because I would expect your HR to know what the rules are. You've got your policy, but HR are going to be there to make sure that you are not going to breach any of those rules. We don't want to end up in an unfair dismissal if you get your process wrong. We don't want to end up in constructive unfair dismissal if you mishandle a grievance. And as we've already seen, the investigation forms such an important part of those. So HR support, then what do we need? So in an ideal world, your HR is going to be there in a supporting role. Your managers or your in-house senior leaders should ideally be conducting these processes to make sure that decision-making is kept in-house. So HR is going to support those managers, support those leaders in these processes to make sure everything is done fairly. Sometimes it's not always possible, because if you are a very small team, you might not have enough staff for an investigating officer, a disciplinary officer, an appeal officer, HR to support. Then you've got all your witnesses. Sometimes an incident pretty much involves everyone. So it's going to be, we need to look at those individual circumstances to see what is fair and reasonable in your individual circumstances. A company that's only got a few members of staff will be given far more leeway than a very large company that has multiple layers of management and support. They're not going to get away with, say, combining an investigating officer and disciplinary officer, whereas potentially we can consider that in your smaller businesses. Not ideal, but as I said, this is not black and white. It is about what's reasonable. So options then, when we include HR. HR, to me, ideally should be the advisory capacity. So HR should sit on the outside of all this process and be there to say, this is what you need to do next. This is how you're going to make your decision. Have you considered all these facts? They're not going to get involved in decision making. They are just going to be there to make sure that that process is fair. Then we've got HR as the investigator. So again, sometimes you don't have enough staff members to be able to allocate all those roles. So the next step could be HR do the investigation. If it's a grievance, HR would generally also be a decision maker, so bear that in mind. If it's a disciplinary though, the parameters of the investigating officer is that they will look at all the facts and circumstances and then pass their findings to a disciplinary officer who makes the decision. Then the third option is you've got HR as the decision maker. And ideally, if HR are going to be making decisions in your business about disciplinary and grievances, they need to be senior, they need to be trained, or you need to be using an external consultant to do that. So it's what suits your business is going to be different. And also it could be that in different scenarios, you're going to have to choose different options in terms of how you want HR involved. So looking at the most common way HR is involved is HR in the advisory capacity. But we have seen case law on this. And as I've said, the role of an investigator should, the role of HR when it comes to investigations is to advise on law, procedure, process, but not on whether someone is guilty, whether you think that they should be subject to disciplinary or, well, they should be fired, for example. It is about process. So in the Shabra case, we saw that the tribunal did support HR in being involved. So they said where the investigator sought advice from the HR department on questions of procedure, yeah, that was okay. There was no impropriety, that was acceptable, and that is the role of HR. However, in Shabra, it went a bit further than that. And what we found was that the investigatory report was reviewed by HR and changed by HR. And the tribunal said that the final report was no longer truly the product of the investigating officer. This is why we need to be so clear in everyone's roles. If HR is advising, that is all they're doing. They're not changing things. They can make recommendations. For example, they can look at the investigation that's been done and say, have you considered this? Have you looked into that? So they can make suggestions where they feel that there are holes in the process. But what they can't then go on and do is say, we're going to tweak this, we're going to change this, we're going to take that out, this needs adding in. So got to be very careful. And then we have the case of wrongful, which involved an employee who was unfairly dismissed, and it was found that the investigation which led to his dismissal had been significantly influenced by HR. So we had an original report which had recommended a written warning. By the time HR had got involved, this had escalated to a gross misconduct and summary dismissal. And there it was found that HR had pulled all the strings. They'd actually been the decision makers all along in that process, and that was incorrect. So again, if you have an investigating officer, they need to be independent and their report needs to be their own. So we do need to be careful as to what level of guidance is being received. So let's have a look at some examples of how we've supported our clients when we've done investigations. So I'm going to pass over to Phoebe Davies, who has done quite a few investigations for our clients, and will be best to tell you, as I said, how we've supported our own clients in these processes.
Thank you, Linz. Can you hear me okay?
I can indeed.
Lovely. So yeah, I've been involved in quite a few investigations that have been outsourced to us, where I've been the investigating officer and the decision maker, but also in an advisory capacity as well. So usually we find that people approach us for some help with an investigation where they're worried about the implications that that person, you know, manager's involvement might have within the organization, because even if, you know, it's not something particularly contentious, it's only sort of a small dispute, managers being involved in that, it can create a bit of a sour taste. It can lead to the breakdown of relationships, and often it's easier for the organisation to outsource that to us, use us as a bit of a scapegoat, and say, well, we're going to outsource this, it'll be completely independent and unbiased. But it's also about time and resources, so it's so much easier to push that out to somebody else and not have to worry about all of the resources and time that it's going to use. But it's the bias, you know, as well, in that it's quite difficult when you can't see the wood for the tree sometimes. You know, you're involved in day-to-day operations within an organisation, and it can be quite difficult to take yourself out of the picture and actually look at it independently, because you have natural bias. And it's, you know, it's not something that you can overcome, but, you know, especially if you've been a witness, which a lot of the time you have, either directly or indirectly. So sometimes it can be easier to just send that to somebody who's got a completely fresh pair of eyes. But then also, it's the complexity. So if it's multidimensional, it may be in response to a grievance that the investigation's happening, but there may be a disciplinary to follow. There may be lots of different points of law in there that you're not really sure of. So often it can be best to just seek support right from the start, because if you complete an investigation or try and sort of muddle your way through, you can't undo that. We've tried our best in some cases to undo bad investigations and redo them, but a lot of the time the damage is done. And there's different ways in which we can help. So as the investigating officer, we would be completely in control of planning that investigation, collecting the evidence, writing a report, and coming up with some recommendations for the employer to follow, whether that be in the case of a disciplinary, we would either say, yes, we recommend it goes to disciplinary, or no, we don't. And ultimately that is up to you as to whether or not you agree with us. But, as the investigating officer, I think the biggest benefit of that is it ensures compliance in a high risk situation. So, especially if there's trade union involvement as well, because I've sat in quite a few disciplinaries with a trade union representative, and the first thing that they will say is, we think this should be thrown out because the investigation was inadequate. And it can be quite difficult when you've got a trade union rep who really knows their stuff, which is what they're obviously there for, to support their member. It can be quite difficult for employers sometimes to make sure that the investigation is as robust as what they'd like. And we had a success story with this, where I was the investigating officer in the case that's mentioned on the slide, and it was a collective grievance. So there were more than 10 employees that had collectively put in a grievance that was about a litany of things that, allegations against their employer. And the investigation took weeks, but we handled that for them. We collected all of the evidence. We produced a really comprehensive report. Ultimately, people were dismissed quite a period of time after that, based on the evidence that had been collected in that investigation. It went to tribunal and our client was successful. And it's not to say that us doing the investigation is going to, 100% guarantee that any claim would be successful. But in cases where it's complex and that investigation has got to be really bang on, I think it puts employers in really good stead. And it sort of reduces the conflict as you go, because we find that employees are much less likely to pick apart the process when we're doing it. And a lot of the time it helps resolve disputes as you go, because naturally in investigation meetings, we will have have conversations with employees and say, well, how did this arise? How do you think it can be resolved? And we'll naturally help with resolving the dispute in the long run. But I've also assisted as a supporting investigator. So that means that my name will be on the report as well. And that's just to make sure that we don't end up in a situation like with the case that Lindsay previously spoke about, where we're accused of influencing a decision. But we're not chairing the process, but we are a supporting investigator. So we can help with drafting the report, help with compiling evidence, and we'll attend all the meetings and draft the interview questions as well. But then if sort of clients, they don't have the budget for that, or perhaps they are really competent and they just want some moral support, we can attend as a note taker. So it just means that, well, you're going to have really great notes because we're quite fast typers, but it also means that you've got that moral support in the meeting, somebody to have a bit of a chat with after, get a second opinion. And it means that we can stop you in your tracks if something is going a bit sour, or if you're about to ask a question that wouldn't necessarily be just about fact. But we are quite careful with the way that we advise on investigations, in that we're never going to tell you what we think you should do, but we will make sure that we give recommendations as to what you should write in the report, the questions you should ask. And a lot of the time when I'm helping clients remotely with an investigation, I'll give them the sentence structure for the report. So I'll give them example sentences as to how to set out their evidence. So I'm not writing it for them, but just giving them guidance as to how that should look. So they're the different ways in which we support clients. So if anyone feels like they need any, just let us know. And it doesn't matter at what point during the process we get involved. There's always an option as well for us to help you.
There's generally always something we can do, no matter.
Yeah, there's always something.
One thing I would say is when we are the investigating officer, particularly, well, for the grievance, and with a case that Phoebe just mentioned, where she did all the investigation. I said that was a grievance which Phoebe did the findings on. And what we're very clear to clients is that if you outsource and if you say, I want you to do this, then we will take hold of that whole process. But if you then override our decision at the end, particularly when it comes to a grievance, then you've just undermined the whole process. So if you are instructing us to be a decision maker, we expect you to abide by our decision, or otherwise the whole thing's pointless. And we have to be very careful, because lots of clients will say to us, I want you to do this disciplinary, so can you be the disciplinary officer, and I want you to dismiss. Happens a lot. We'll always take on board what your aim is, but we have to weigh that up against our own independence and what is going to stand up in a tribunal. And we have been in many situations where we've had to say to a client, I understand what you're saying. There is not enough evidence here to dismiss, and I won't put my name to a dismissal if I don't think it's fair. So we'll always give you the best advice we can, and sometimes it might not be the advice you want, but we're keeping you safe. So, and that's the whole point of HR involvement, is to keep you out of the tribunals. So then, what is the actual role of investigator? Let's go back to some basics. The investigator is someone who's impartial. They shouldn't have been involved in the process at all. They shouldn't have witnessed it. They shouldn't be best friends with any of the parties involved. They need to be independent so that ultimately their report is impartial. And they're there to establish the facts of what happened. They're not there to only provide evidence that supports a certain aspect. They're supposed to look at everything. So it's not about proving guilt. It is about looking at the whole situation and being able to provide a report on what actually happened, who saw what, when did they see it, and you include pretty much everything. Obviously, it's got to be what's reasonable, but as I said, you can't be selective in what you include. And that all comes down to the whole point of being independent and impartial. So before we do the investigation, we plan, and planning is so important. We need to know what's going to happen, when it's going to happen. So your order of events. Are we suspending anyone? What evidence are we going to need? What witnesses are we going to need to talk to? On the back of that, well, what's the time frame? You know, as Phoebe mentioned in the example that she gave, where she did the grievance, there was definitely over 10 employees in a collective grievance. Phoebe had to speak to all of them. Everyone got spoken to individually, and that takes time, but that was planned into the process because we knew from the start how many witnesses or how many people needed to be spoken to, so we would be able to be transparent right at the beginning to say that it's going to take so many weeks because of X, Y, and Z. So if you've got your plan, you can give an accurate time frame, you can manage everyone's expectations, and then they should hopefully avoid grievances arising during processes because things are taking too long, or people feeling like, for example, those on suspension can sometimes feel very isolated and they don't feel anything's happening. As long as you can prove, no, things are happening, it's just taking some time, then that's another layer of protection that you're adding. And then we need to think about how we're presenting this investigation. So that will depend on what type of investigation is what you're investigating. Is it necessary to do a full detailed report? Is it evidence-based? So is it just a matter that you've gathered lots of documents that are self-explanatory? So presentation of the investigation will differ depending on the exact circumstances. So deciding on the order of evidence to be collected, again, highly dependent on what has actually happened. And again, I'll give you that example of a complaint coming in about, say, a specific manager. Then really your first port of call should be to speak to the person that's raised that, not send that grievance out to that manager straight away. It might be actually they want to be the last people we speak to. So deciding on your order, I said, will be very dependent on the facts. Sometimes it's going to be really straightforward. More often than not, you need to speak to the person who it involves straight away, so you've got a full understanding. If it's someone who's raised a grievance, speaking to them first means that you know exactly what the case is about. If it's a disciplinary, speaking to the person involved in the disciplinary can be a good start for you, because it might be that they say, yes, I did do that, I'm really sorry. That doesn't mean you don't have to investigate further. It just means that's then going to completely tailor what you do next, because you might not need to go to the nth degree that you planned, but you still need to make sure you've looked at everything. Deciding whether suspension's appropriate. So this is always a tricky one. It's all going to depend on the facts. Suspension generally should be a last resort. It should be to protect other employees, to protect evidence, to protect the business, sometimes to protect the person that's actually suspended. So it needs justification as to why it is necessary. We need to be looking at the contract to see, have you got in there a clause that allows suspension, and then we need to look at on what terms suspension's allowed on. So generally speaking, we always say someone should be suspended on full pay. There's very few exceptions to that, and also that serves as an incentive to you then to get on with your investigation. The NHS, I'll name and shame them, are notorious for having people suspended. But I've known them being suspended for over a year, and they're paying the full salary during that time. That's not helpful for anyone, because the longer the time goes on, your evidence isn't going to be as fresh, your employees are going to lose faith in you, you're going to end up in a claim in some way, shape or form. So that's where the breach of trust and confidence comes in. So if you make the wrong call with suspension, either you suspend someone when you shouldn't have done, or you allow someone to be sat on suspension for a long time, you don't communicate with them, you don't give them updates, then we could end up breach of trust and confidence, which is a constructive unfair dismissal claim. Also, mindful of discrimination, making sure that, say there's two parties in a fight, you don't pick one of them to be suspended and one not on the basis of, say, a protected characteristic. You might not actually intend to that it be based on a protected characteristic, but your decision overall will come off as discriminatory if you only pick one person and not the other, and you can't explain why. So we just need to bear that in mind. And then we need to look at possible sources of evidence. So again, this comes in your planning. It's hard to say, I can't give you a list of everything you need to look at because everything is different, but I'll put some ideas here as to things that you need to be looking for when you're deciding what you need to gather. And again, I'm highlighting here, an investigation only needs to be reasonable, not exhaustive. You don't need absolutely, everything looking at. If an incident was witnessed by 50 people, it is actually probably going to be excessive to interview all 50, because chances are they've all seen the same thing. I do think you need to select a broad selection and make sure you look at different perspectives, but 50 statements could be a bit OTT when they're all going to say exactly the same thing. Emails, timesheets, payroll, letters, pictures, text messages. Oh, we see a lot of WhatsApp messages now. So yeah, they're not private. People will come forward with those. We've seen some doozies when it comes to sexual harassment over text messages. We've seen inappropriate pictures being sent. And CCTV as well. You should always be transparent with staff about where your CCTV is. Everyone should know. However, it still catches some people out. So yeah, we've seen some interesting CCTV over the years. But again, planning, make sure you've looked at, have we got everything? Do we know where we're going to find it all? Also, how long is it going to take to gather this? So CCTV, most people have it on a rolling, say like 30 days. So you've got to be quick with that. You need to get in, make sure you get copies of it. Emails, items, some things might take a long time to get or to gather or request. Build that into your time frame when you know what you're looking for. So when do we interview an employee in investigation? So I think I've already touched on this. We try and do it as early as possible, but ultimately it will depend on when it is appropriate. The general rule is that until you have spoken to the person that is involved in this, you're not going to fully understand the facts. If you do all your investigation beforehand, then you speak to the person involved, they have a completely different spin on it. You might have to redo parts of those investigations because they might be able to identify the witnesses, other pieces of evidence. You know, it makes sense to speak to them first, so you know what you're doing. Also, as I said, if someone admits straight away that they've done something, that then might tailor how you move forward, because you probably won't need to go to the lengths that you would have done previously, but we still need to show that we've fairly investigated the whole thing. So just their word isn't going to be enough, but it will help. And then letting them know. So this is a question that we always get asked. Do we need to tell them? So say, for example, you've got allegations of misconduct. Do we need to tell that person we're looking into them? Well, certainly they're going to need to know if they're suspended. Then we've got to think about, you know, is it appropriate? And more often than not, yes. The answer is yes. We should be telling people that they're being investigated. There's going to be very few circumstances where it's not appropriate. For example, if someone might be able to influence or tamper with evidence. However, then I would be thinking about suspension anyway. So what we do, we write to them, ideally, so you've got everything black and white. When you write to them, you don't need to tell them exactly what they are being investigated for. You can keep that quite loose and broad. This frustrates employees no end. And lots of people will, you know, we get lots of phone calls saying, I've been suspended or I'm under investigation and they won't tell me what it's for. That's wrong. You know, they're completely breaching everything. Actually, they're not. You don't, because these are only allegations at this point, you don't need to give them all the details as to why they're being investigated. As I said, it can just be a very broad overview. But they do need to know, is there going to be a meeting? When's it going to be? Who the investigating officer is? They need to know, are they going to be able to bring anyone with them? They also need to be aware that they'll have to keep it confidential. Also, what will happen if they refuse to cooperate with investigation? It's good to tell them at that stage what's going to happen. And generally speaking, failure to cooperate with investigations is refusal to carry out reasonable instructions, and therefore could be a disciplinary offence. So we need to make sure everyone has all the facts before they make any stupid decisions, they do anything daft. But also it'll give them the reassurance that this is being dealt with and it's going to be dealt with fairly. Ideally, at the point that you tell them that they're being investigated, you might already have your time frame in place because you'll have been able to do most of your planning. So giving people time frames, telling them when they're going to be communicated with, how often they're going to receive updates, will really help the process go a lot more smoothly. At a meeting, and what is an investigation meeting? I think it's easier to say what it's not. It is not a disciplinary. Even if someone says to you, yes, I did it, you can't then turn around and go, oh, well, in that case, I'm dismissing you. Wrong. Even if they admit that they've done horrendous things, that is still just the investigation meeting. It is a formal meeting, but it is not a disciplinary. And we have separate rules for disciplinaries where we have to do invites. We've still got to have an investigation. Someone has to be able to represent themselves, and also they need to be able to bring someone with them. Completely separate rules for your disciplinary meeting. So the investigation just needs to be, or this meeting, it needs to be just to the facts of, well, what happened. You shouldn't be expressing an opinion. You shouldn't be, you can probe someone, you can really question them, but what you can't say is, I think you did it, because then you're not being impartial. So you need to be really careful what you say at these meetings. It's in terms of inviting them, so going back to, ideally, it is good to invite someone to a meeting so they know what they're coming to and what it could be, but it's also not incorrect just to invite employees in and say, this is an investigation meeting, being very clear, it's not a disciplinary, I just want to ask you a few questions. That's okay too. Sometimes you get a bit more backlash though when that happens, because an employee will suddenly go, oh, you're dismissing me, I demand representation, and etc. So being a bit more transparent tends to work better, but is not always necessary. So can they be accompanied? Actually, we don't have an automatic right to be accompanied to an investigation meeting, because no decision should be made. You don't need anyone with you. If it was a disciplinary, that is different. If it was a grievance, again, you're allowed someone in there because a decision could be made that could affect you. But I always think you need to think carefully about if someone wants someone in there with them, and also check your policy, because actually your policy might determine whether they can bring someone in. Always abide by your own policies. But it's always worth looking at a request, because it could be the need for a reasonable adjustment. If someone suffers from anxiety, depression, and they're saying, I need someone with me just to help me, yes, I would recommend you allow that in. I would still say stick to the general principles of colleague or trade union rep. However, sometimes a family member can be more appropriate if it's quite a sensitive topic. Never, don't allow solicitors in. We're pains. Don't let us in. It's very rare we're allowed in for that reason, but do check up on who someone is bringing if you are going to allow it. Be careful. So what notes should you take? So normally, if you're bringing someone in for an investigation meeting, that record of that meeting will form part of your overall investigation. So we need to be careful what notes we write down. Certainly don't write down, I think they did it. Not going to help you. That's going to be disclosable. So we want to make sure that your notes are, again, just a reflection of what was said and what happened at that meeting. They need to be accurate. We recommend that you get the notes signed at the end. So if you've done handwritten notes, you allow the attendee to read them, sign at the bottom, and then they can't come back and say that you've changed anything or added anything in. So yeah, just be careful what notes, because everything we do as part of an investigation, we need to assume that at some point a judge will read it. So it's got to be fair, got to be accurate. So tips then. Before you go into any investigation meeting, we always say have a pre-planned list of questions. So this helps you both make sure you stick to the facts, you remain focused on the events, but also it shows that you are treating everyone fairly. So if you're interviewing more than one people about an incident, you're asking them all the same thing. Shows consistency, shows fairness, gives everyone the same opportunity to put forward their version of events. As I said, do probe though, do ask follow-up questions. Don't be afraid of silence. That's a key technique in prompting and encouraging someone to speak or elaborate. Silence is uncomfortable. So you need to be the one that can abide by it and say, right, I'm just going to be a bit quieter now. I'm going to see if they're going to try and fill that silence and give me a little bit more information. Also, we need to be prepared that sometimes during these investigation meetings, more issues can be thrown up. More allegations can arise, other key concerns can be raised. And although that is not your primary job to investigate those external issues, it is your job to pass them on. So if someone makes a disclosure to you that is really serious, you shouldn't ignore that. You should refer that back to either HR, your manager, and say, this has come up. I think it probably needs to be dealt with separately, or we need to make a decision as to whether we deal with it as part of this. But either way, it shouldn't be ignored. And people do like to throw in these little bombs. It's often to try and deter things or to get things off track. But just make sure that you're ready and you've got a plan in place for those. So handling a refusal or failure to attend. So I think it's important that people understand at the beginning how important investigation meetings are. So if we're inviting informally, that's your opportunity to say, if you fail to attend or and your excuse to attend isn't reasonable, then we may look at this as a disciplinary matter on the basis that you fail, you're not following reasonable instructions. But do look at the reasons why they can't attend. If they are ill, if you have said to them they can't have someone with them, for example, and they really want that, that's where you need to think, am I being reasonable? So reasonable is our key test. I always say it's always reasonable to arrange a meeting at least once, particularly if there's a valid reason. Second time, if there is no valid reason, then you are then open to go ahead and, well, you wouldn't have the investigation meeting on your own, but what you would be able to put in your report is that they were given the opportunity to attend, they failed to provide a valid reason for attending, therefore they're not able to contribute their own evidence, and you can only then make your conclusions on the evidence that you have available to you. So they're detrimenting themselves if they don't come, because they're not being able to put forward their own version of events. I just skipped one. There we go. So writing your report at the end. As I said, reports will look different. The one that Phoebe was referring to earlier, as I said, that was a collective grievance. It was massively complicated. There were so many issues. Her report was, I want to say, it was certainly in excess of 50 pages by the time it was done. That's how big and detailed it was. And that was needed because the issues were complex. We also knew quite early on that it was going to end in litigation, so it was thorough. A report that size and that detailed isn't always needed. And as I said, sometimes it might not be a report at all. It might just be a collection of all the documents that you've received, for example. If you are doing a report, though, in a grievance, you do need to make sure that you're determining on each point so that you're not leaving anything unaddressed. So your report can either be your outcome and conclusion, or you can put that in a separate letter. So you could do your investigation report and then put all your conclusions in a separate letter. Sometimes your report forms the whole grievance outcome. So it depends how you want to do that. In a disciplinary, obviously it needs to be all your evidential findings. It needs to be written in a very neutral way. You shouldn't be putting unnecessary opinions in there. However, you can express an opinion as to whether you think something was reasonable or not, or whether on the balance of probabilities you think something happened or didn't happen. But make sure you can justify that based on the evidence. If it is just an inkling that you have, or a personal opinion, I just got the impression, I wouldn't put that in. Getting the impression or suggest to me that you've got nothing to back that up with. So it needs to be based on all your evidence. And then in a disciplinary, you can say whether you think further action is required. I do not encourage HR to put in there, I think that this is a gross misconduct offence, because that could be seen as overstepping. But what I tend to say, it should be limited to, this should now be escalated to a formal disciplinary process. And then you allow your disciplinary officer to make the call on how serious is this, does this need to proceed? Because what the report in a disciplinary process is for is to allow a disciplinary officer whether to proceed or not. It's not down to the investigator whether something should proceed to a disciplinary. I need to make that very clear. The deciding officer makes all the calls in respect to that. They could read your report and they could say, I don't think any further action is justified. And that will be the end of it, because they're the decision maker, you are not. So again, what it shouldn't include, you shouldn't leave anything open to accusations of bias, you shouldn't filter evidence, and like I said, I'd advise against not including determinations on sanction. I just think it can get you into hot water. So key considerations then as we go through this. What will you disclose and who to? So we've recently had this crop up actually in a grievance that we've dealt with, where the grievance was against another one of the senior management team who said, well, I want to see it all. I want to see the grievance. I want to see all the evidence. And we had to say, you're not the person raising it. And no, we don't have to disclose that all to you. However, we did need to be mindful of the fact that everything we'd collated could be presented to a tribunal. So, it's not that someone will never see it, but you do need to be mindful of when it is appropriate to. And someone's grievance actually should be confidential to them. The people that they, for example, made accusations against do deserve to know certain things, but they don't necessarily deserve to see absolutely everything to do with the grievance. It wasn't their grievance, so be very careful. The other thing I've said before is, as I said, lots of things are going to be disclosable as part of any tribunal claim, but also you need to be wary of subject data access requests. So these are made under data protection, GDPR. Everyone's entitled to receive any information that the company hold on them if they make an appropriate request. And what people forget is that this includes email correspondence between HR, managers, or correspondence between different levels of management. HR, you are not protected with legal privilege, just to be very clear. Your decision making, your advice is not protected unless you seek advice from an actual legal professional. You need to be very careful, because you're not automatically going to be able to claim legal privilege or litigation privilege. So everything you write down, you need to be prepared will be viewed by a judge or by the individual. Make sure your managers know that they're not to send emails between themselves saying, we need to sack Joe. Make sure that Joe's dismissed. Also, derogatory emails that because I think everyone likes to have a rant. Make sure everyone knows that their emails need to be squeaky clean, because it's going to come up and it could show that actually the whole process was biased. So very careful, massive word of warning on that. And then I've just put a case in here just to demonstrate when legal advice has backfired. And it generally doesn't backfire, but in this case, it was an example of to what extent you can argue legal and litigation privilege. So in this case, HR drafted, or an individual within the business drafted the first draft of an investigation report. They then sent it out to external legal advisors who made amendments. Advice from external advisors is generally legally privileged and is non-disclosable. However, the legal advisors in this case said, we think you should make X, Y, and Z. Amendments were made to the report. The report was then disclosed, obviously as part of the process, but then ultimately as part of the tribunal claim that followed. It was very clear, because I think they actually put on the report the date that it was amended. So there was a review date on the report. So it was clear to the person who'd received it that this had actually undergone amendments. So what they did was they requested the copy of the first investigation report. And the first investigation report was found to be not covered by legal privilege. It had not been prepared by a solicitor. It had only been sent to a solicitor to review. So therefore, it wasn't covered. And that you could then take that first version, the second version, and see what the legal advice was. And it was argued that that wasn't fair. You shouldn't be able to see the legal advice, but because of how this happened and that first report not having legal privilege, because it wasn't prepared by a solicitor, meant that the whole thing was disclosable, and it was very clear then what advice they'd received. So privilege is a minefield. I could talk about that, quite, in a lot of detail, but it's not appropriate for today. However, if you've got concerns about it, you feel free to ask questions. So we're going to try a new thing now. All right, I'm going to wake you all up because I've been talking to you for a while. So we're going to do a quiz. So what I would like you to do is get your phones, and I want you to scan that QR code. And what that will do is take you to a site called Slido. You'll be asked to put your name in. You don't have to put your real name in if you don't want to, because unfortunately there is, at the end, it does collate answers, but I'm going to skip over that. This is not about scoring. This is more about a discussion piece of, I want to show you an example and I want to work through it together. So I hope everyone should now have scanned and joined the Slido, and it should be up on their phones. I'll just give you another few moments to do that. It is easy to use, I promise you. I'm not tricking you, and you don't have to download anything either. So it just takes you to a website which you can then close afterwards. So you're not obliged to sign up to anything. I don't think they should be asking for your email address. You are just taking part in a little quiz. And as I said, what we're doing as well with this is I'm doing this instead of breakout rooms, because we normally do a breakout room at this point. Sometimes it's hard to say how many people are going to attend these because we have lots of dropouts because they are free. And I thought we'll try this instead of a breakout, but in the feedback, I'd be interested to know how you find this, whether you prefer an interactive quiz or whether you would like to go back to breakout rooms where we have a bit more one-to-one interaction. So hopefully everyone has scanned. And right, let's now have a look at our case study. So this is a company. I haven't named it, but you know, we might call it Simpsons Limited if you want to. It's a small company. We've only got 2 directors. We've got Homer and Marge. There's 2 senior managers who are Lisa and Montgomery. And then we've got 3 employees who are Bart, Maggie and Ralph. So I said, we're not a large company. We have an incident in the office. Bart and Ralph kick off. There's an altercation. There's swearing. There's almost violence. Marge steps in. She breaks it up, so Marge is present. Lisa is also sat in the office, as is Maggie. So they see everything what happens as well. Both Bart and Ralph are suspended because obviously their actions were potentially violent. And in this case, I'm not going to go into the full reasons for suspension, but particularly when you've got violent incidences and you're going to have to interview employees, you've got to think about the fairness overall. And in this case, it was deemed that it was appropriate to suspend. So we're going to look at a few questions. So obviously we've got the incident. We know what the issue is. There's been an altercation in the office. We don't really know what it's about yet, but your role here is HR in an advisory capacity. So you get a call from the company saying, this has happened. What do we do? So we're going to answer, or I'll try and answer together, a number of questions. First one is, who would you recommend to carry out the investigation? So when you're deciding, I want you to make a note of the answer, because then what you're going to do is actually put that in on your phone. The question's going to pop up on your phone and you're going to be able to answer that question on there, so we can all share our thoughts with that. So who would you recommend to carry out the investigation? Think back to roles. Think back to what we're going to need going forward. Investigation. And here I put the rest of the question, so that should give you some guidance on where I'm heading with this. Investigation, witnesses, chairing disciplinaries, chairing appeals. Who are going to use for all those things? But initially, investigation. So hopefully everyone's had a chance to have a little read of that. I'm now going to flick to the answer to the quiz slide. So look at your phones and you should be asked the question. So this will say to join. Make sure you've all joined. It'll tell me in the corner how many people are coming on board. I can see names. We're all coming on. Yeah, we're all coming. A few more. Also, just if you haven't had the QR code is there as well, just in case. So I will give you all just a few moments to make sure that you're on and everyone's sorted. As I said, this is optional. It's supposed to be a bit of fun, so don't worry. No one's going to be named and shamed, promise you. Although I have noted Hannah on there. Hannah's one of my team. She should know the answers, but we'll see if she gets it right. So we might name and shame Hannah. So you best be paying attention. Right then. So the question was, who would you recommend to carry out the investigation? So I'll give everyone a few moments to pick their answers on the phone. So Homer, Marge, Lisa, Montgomery, Maggie. I've obviously excluded Bart and Ralph. They're the people, they're the people that had the fight, so they aren't going to do their own investigation. So, right, 15 out of 18 have answered so far. Should be 3 more of you making a decision. Anyone else? 2 more? Someone undecided? Just do a guess. If you're not sure, just do a guess. As I said, we're not naming and shaming, don't worry. And also we are going to come back to the question as well, so you don't need to memorize everything what happened. Right, we've got 17 out of 18 answers, so let's have a look. So we had some people think Homer, some Marge, some Lisa, and some Montgomery. So, and also the independent consultant. So actually, other than Maggie, and have in mind, Maggie is an adult here. I don't want you to make any assumptions on Maggie's age. But overall, we're thinking 44%, we're going to have Montgomery. My view and my recommendation is, but yeah, I think we should have Montgomery. So I agree with the majority there, and I'm going to tell you why. So going back to our scenario, we've got, and this is going to give you pretty much the answers to the next ones as well. So I'm going to try and be careful, but we've got to think who's being involved. So who are our witnesses? Is it appropriate for a witness to investigate? What about the senior leadership? Because ideally we want a senior leadership person to be the decision maker. So I would say the majority got that right. I don't want to give it all away because I will explain all my thought process afterwards, I promise you. Well, let's move on to our next question then. So we've got Montgomery now. He's going to be our investigating officer. So who are our witnesses? This should be a bit easier. So read back through what happened. So we've got Bart and Ralph. But who saw what happened? We know Marge broke it up. Lisa's there. Maggie's there. Homer, where's he? Where was Montgomery? So who would we have? Just make a mental note or write that down as to who your witnesses are. For this one, you can obviously select more than one. Hopefully everyone now has had a look through and decided who are we going to interview as witnesses. So you all need to just join again. So let's get ready. Right then, so who are the witnesses? We've got 19 now on board. 17 have answered. 18. Right, everyone has answered. Who are our witnesses? So this one's a bit of a landslide. This one's a bit easier, isn't it? Marge, Lisa, and Maggie. I agree. They saw it. So going back to our scenario, Marge breaks it up. Lisa's there, Maggie's there. So logically, they're going to be our witnesses. So we've now got, to summarise, we've got Montgomery investigating because he wasn't involved. So Montgomery was not part of any of this. So actually, it makes sense for him to be the investigating officer because he wasn't there on the day. So he's going to be independent. We've now got our list of witnesses. So moving on to our next question, who would you recommend to chair the disciplinary? So recap, Montgomery's doing our investigation. Marge, Lisa and Maggie are our witnesses. So who do we think is appropriate to chair the disciplinary meeting? I'll give you another second just to read that back through. Make sure that you've all mentally made your answers. And then we'll move on to see what you all think. So enter your answers now. Feel like a quiz master. We've got 20 on now, 17 have answered. In there you will see I have added an extra option. of an independent HR consultant. So I don't know whether that might change some of your answers now that I've thrown in an additional option that I didn't tell you about previously. So we're 19 out of 20. Give you one more moment. And then we'll see what everyone thinks about who should chair the disciplinary. Right, so we've got an overwhelming there of Homer, 74%. Some people think at this point we should actually get the independent HR consultant involved. So that could be an idea. And I don't necessarily think that is wrong. And if you are a company that, say Homer's got limited resources, then that could be an option for you. So I don't think that is wrong. But if you are trying to keep everything in-house and you want to be in charge of your own decision-making process, then to me, Homer would be your best option for that, because he's a director, he's someone senior. It's, as I said, by this point, we're assuming we've looked at your policies, and that's been very clear that we can make all these decisions. So we've got Montgomery as your investigating officer. We know that Marge, Lisa and Maggie saw it all, so they're going to be they're going to take part in investigation meetings, provide witness statements to Montgomery. Montgomery's then going to put it all together in a report and is going to pass it to Homer. So in that case then, who would we then use for an appeal? So these, and we've got the option again that will be available to you on the next slide of an independent HR consultant as well. But who are we going to say for an appeal? Have in mind, an appeal is not guaranteed. You may not have an appeal. So we want to think about it at this stage, but it might not be something that we have to, we have to utilize. But like I said, it's good planning. So who are we using for an appeal if we have one? There were 18 out of 20 have answered, nearly all there. I'll give you just one more moment. Who is chairing our appeal? So we've got, 11% think we should use Homer again. So we'd already got Homer down for the disciplinary, but potentially, yeah, we've got him for appeal. Montgomery, right, we'd earmarked him for the investigation. Can we also use him for an appeal? But I'd say the majority there are for the independent HR consultant. And I think, again, I would agree, because, again, if we go back to our scenario, sorry, I've added a little bit on here, so this is going forward a bit. But going back to our scenario then, we know that we've got Homer, who is the most senior person that is not involved in this process. So we want him to be a decision maker. And we also know that we might not go to an appeal. We can't use Marge because she's a witness, ideally. Lisa's a witness. Montgomery did the investigation. And then Maggie she's too junior, surely, so we can't use her. So in an ideal world, if we're trying to keep your costs down, and I'm advising you, I would be saying, because the appeal is unlikely, or well, not unlikely, but if we do everything right, we can minimize the chance of an appeal. I would say independent HR consultant to get involved at that point, but you've got to be prepared to hand over the process. And also, if necessary, and I'll use a real life example here, I represented a company that were very small. They only had two senior managers. It was a pub, the rest were bar staff. And the manager, the owner, found that an employee had been stealing from the till, the CCTV. Quite enjoyed watching that. He did the investigation, and he asked that employee what happened. The employee's response was, oh, well, the money I took from the till I didn't keep, I gave it to the other owner. So have in mind, we've only got 2 owners in the business. I gave it to the other owner. So he speaks to the other owner who says, nope, she did not give me any money at all. So then we've got a predicament then, because the other owner now becomes a witness. We've only got one senior manager, and also he did this without legal advice. I will add, I didn't get involved until the claim had landed. But what he did then was, because it was just him and he wasn't fully aware of the Acas guidelines, he did the investigation. He then did the disciplinary. He was then also the investigating officer. Big no-nos on so many levels. But I will tell you the happy ending on that one. Although the judge said it was not ideal, the judge found that even if a proper process had been followed, it would have still resulted in the same action. And the judge was lenient because they were only a small business of 2 owners and junior staff. So, and they didn't also have the money to outsource. So again, it's a really good example of what the judge will look at. And it's not just the black and white facts. It is the reality of what's in your business. Right, I've got one more to throw at you. So you may have already been having a read. So we're going to we're going to change things up, and this will often happen in your process. So Montgomery started investigating. We wrote to Bart and Ralph and we said, Montgomery's your investigating officer. Then Bart puts in a complaint and says he's got an outstanding grievance against Montgomery for bullying. What do we do with that information? So Bart is not happy that Montgomery is doing the investigation and would like someone else to be appointed. What's our advice at this stage? So we know we'll support the fact that Bart has put in a formal grievance against Montgomery previously that is still being dealt with. So what would your advice be? No change to the investigating officer. So we keep Montgomery in place because that grievance is completely unrelated to this. It's nothing to do with this process, so let's keep him in place. Do we appoint Marge or Lisa as the investigating officer as the preferred option? So we boot out Montgomery and say, no, we'll appoint Marge or Lisa. Do we move Homer to the role of investigator and now have an independent HR consultant chair the disciplinary? Or do we instruct an independent HR consultant now for the investigation and appoint Homer to chair the disciplinary? So getting your, like I say, HR advisory hat on, what would we be telling this business to do as the best course of action? So I'll give you just another moment to read through those options and make your decision, and then I'll ask you to vote again and see what you thought would be the best course of action. So answers on your phone, please. What would you advise? So to recap, Bart is not happy that Montgomery is investigating. Already has a grievance against him for bullying. Do we keep Montgomery as the grievance officer? Do we appoint Marge or Lisa, which I'll throw you some information. We already know they're witnesses. Or do we move Homer's role to an investigating officer, get an independent HR consultant involved? Or do we move... Oh, sorry, the answers are wrong there. I've just realised that's wrong. The bottom answer should be, as previously advised, I should have checked this one. The bottom answer should read that Homer is the disciplinary officer, the HR consultant is the investigator. So I won't take your answers fully to things. I appreciate that. I've thrown you a curveball. I've made this a bit more difficult than what it needed to be. So let's have a look. So yeah, I did throw you a curveball with that one, I'm afraid. So I do apologise, but some of you saw through my mistake. So some of you thought no change to the investigating officer because it's unrelated. my advice would be that actually we bump home, we keep Homer for disciplinary, and we use the HR consultant for the investigation. So reason, my thought process behind that was, so look, you can see the proper answers there at the bottom. My thought process on that is that actually you want to keep your decision making in-house. So the role of the investigating officer isn't to make a decision, they're there to look at all the facts. So actually you should be able to parachute in an independent HR officer to do your investigation, and they should then present to, in this case, Homer, the disciplinary officer, who will make the final call. And these things happen a lot. We often get challenges to investigation officers, to disciplinary officers, and sometimes there are genuine challenges, in which case it's not appropriate. Oh, sorry, sometimes they're not genuine challenges, in which case it's not appropriate to change, but sometimes the challenges are genuine. And we do need to rethink roles based on what's said, because my fear would have been that if we'd have kept Montgomery in place on this one and kept him as the investigation officer, but would immediately have appealed any decision on the basis that the investigation was flawed. It was done by someone who he'd accused of bullying, therefore it was bias. And that we don't want that. So if we can avoid it, we will. And then again, my example that I gave you about the tribunal shows that if you are a small business and you don't have the money to outsource, potentially you can get away with doubling up on roles. It's not ideal, it puts you at more risk, but the tribunal can be understanding about that. So I hope you all enjoyed that. I do apologise for that last question just being incorrect, because I know that I threw you all off with that one, but overall you did very well. And as I said, this was something we were trying different to the breakout rooms, and to be a bit more engaging, but also be able to go a bit more in depth into a scenario that is more likely to happen in your business. So as I said, we get curveballs all the time. We need to plan, evaluate, but also be prepared to be flexible for if something happens. And that concludes our session today on investigation. So I hope you've all enjoyed it. If you want more help and support with investigations, or generally with HR, we do offer really in-depth training courses. They're amazing. The depth that we can go into, what we can cover. You can come along to one of our pre-planned sessions, such as HR Essentials, or we can devise you your own. So at the moment, we're going out to businesses where we've planned a whole training session based on their needs. We've also, like I said, in the diary, we do have some pre-planned sessions as well ready. Ellie Han tends to deliver us our training, and as you can see there, she's got some amazing reviews on the training. So if you do have any questions about our training courses, let me know. We're also Skills Bank approved, which means that we can now apply to get costs and money off of your training, and most companies will receive between 40 and 60% off their training costs if they qualify. So do speak to us, because it might be that we can get your costs reduced when it comes to training. And then looking at what we've got coming up, the first event we've still got some places on our flight and fromage networking event. So if you are in Sheffield and around Triple Point on the 10th of July, please book on early, because as I said, we haven't got many places, but do come and join us for our networking event, which is the whole world of beer and cheese. Who doesn't like those? So you can book onto that. We've still got some spaces. Then quality and diversity, we've got a one-day course coming up in August. On that one, I'm going to show you, you'll see there on the quality and diversity and the HR Essentials 2-day course, we have got some places that have a guaranteed 50% off. So half the price of the course. If you are interested in attending on one of those half price seats, let us know. You have to be a business in South Yorkshire, but other than that, we've managed to cut a lot of the red tape out when it comes to Skills Bank. So please do ask us to see if we can get you in on those discounted seats, because it's amazing value for money. I mean, a 2-day intensive HR course that will bring your staff up to speed, that could train up your managers for only £500. Brilliant. We've also got some charity talks coming up in person and on Zoom, and then our next HR exchanges, we've got one in October, one in December, so do join us for those. Right, any questions then? I think you've all been quite quiet as we've gone on. But do, like I said, we're going to hang around just for a few more minutes. So if you do have any questions, either please unmic and unmute and do ask, or put it in the chat box and we can answer those. While you're thinking about any questions you might want to ask, I will just tell you just a little bit more about us. As I said, we work with lots of different businesses, charities, we work with the hospitality sector, we work with law firms, and there's always going to be a way in which we can support your individual business, whether that be via training or whether that be via our watertight plan, which is like I said, that's our HR support package. We become almost your external HR. We have different levels now, starting from £99 plus VAT per month. So please do look into that. You can see all the information on our website. It's so beneficial to have proper HR support in your business. And I always say people think HR is a non-profit making role, but if it's done right, then actually it reduces sickness. It makes your staff more productive. Presenteeism, we can address so many different things and we can help your company grow. So no, HR is not a non-profit making role. HR can make your business a lot of money, it just needs to be done right. And then also we just ask you, please fill in the feedback forms that we send out to you. It really helps us shape our future content and how we deliver, and also understand what you enjoyed, what you didn't enjoy. And a review as well is really helpful. It makes sure that we're on the right tracks, but also encourages others to come along to these events. And please do stay up to date with us as well. Here is a QR code for our newsletter. So we send that out, I think it's either every 2 weeks or every month. Oh, sorry, our monthly newsletter it is. Give you lots of great information and updates. So if you're in a HR role, it's a necessity. So do scan that. And then if you just want to stay in touch with us, then our details are here. So hello@bayanilaw.co.uk, or just get in touch, pick up the phone, drop us an email, get in touch on social media. That is the end of today's session. I will leave you though with our QR code slide. As I said, let's just see if there's anything else that you want to ask us. As I said, please feel free to unmic. I will just hang around just for a few moments just to see if there's anything else. But thank you so much everyone for attending. Please do fill in the feedback forms. Please do leave a review. Tell your other colleagues there's no limit on how many people from a business can attend these events, and they are free. So I hope you've enjoyed it. Enjoy the rest of your day.
Thank you.
Thank you. I'm surprised we've had no questions. I thought we'd have been peppered. Right, I'm going to close the session because I don't think anyone's got anything to ask me. But again, thank you very much, everyone, for attending.